Hello students, in this lecture we shall discuss certain questions which are important questions in respect of legal and regulatory aspect of banking, a part of JAIIB exam. These questions will be discussed along with their explanations. Let us see first question. A contract of indemnity differs from a contract of guarantee. How? There are two parties in indemnity and three in case of a guarantee. B. Liability in case of indemnity is contingent, in case of a guarantee subsisting. C. In case of indemnity there is one contract, whereas in case of a guarantee there are three contracts. And these are our options. Before answering this question, let us examine these options by one by one. First option is, there are two parties in indemnity and three in case of guarantee. In case of indemnity, one party is indemnifier, other party is indemnified. So this part is correct. In case of contract of guarantee, there are three parties. One is surety or guarantor, another creditor, and other is principal debtor. So there are three parties in case of a guarantee. So this part is correct. A is correct. Let us examine B. Liability in case of indemnity is contingent. In case of a guarantee it is subsisting. So in case of indemnity, the person who has given the indemnity is liable only if there is loss. It means it is contingent. In case of a guarantee, as long as borrower is liable, the guarantor is also liable. It means it is subsisting. As long as borrower liable, guarantor liable. It means it is subsisting. Third, C. In case of indemnity there is only one contract, but in case of guarantee there are three contracts. In case of indemnity, there is one contract between indemnifier and indemnified. In case of a guarantee, there are three contracts. One between surety and creditor, another between creditor and principal debtor, and third between principal debtor and creditor or surety. So there are three contracts. It means all three options given here are correct. And when we look to answer, it means A to C all correct. So this is our answer. A is the correct answer. Let us see question number 2. RBI can remove chairman or director of a bank under which act, against which appeal can be made by him to central government within how much period from date of communication of such order? And here we have the options: RBI Act within 45 days, Banking Regulation Act within 30 days, Banking Regulation Act within 45 days, and RBI Act within 30 days. Now let us first understand what is the legal position. In terms of Banking Regulation Act, Reserve Bank of India has the authority to remove the chairman or director of a bank subject to certain conditions to be fulfilled. So that director or chairman जिसके अगेंस्ट ये ऑर्डर पास किया गया है वो सेंट्रल गवर्नमेंट को अपील कर सकता है और अपील का टाइम लिमिट है 30 डेज का. सो इन द लाइट ऑफ दिस अब हम इस क्वेश्चन के आंसर को ऑप्शंस को एग्जामिन कर सकते हैं. आरबीआई एक्ट नो, बैंकिंग रेगुलेशन एक्ट यस, 30 डेज यस, 45 डेज नो. सो आंसर बी इज द करेक्ट आंसर. रिजर्व बैंक ऑफ इंडिया किसी बैंक के चेयरमैन को, डायरेक्टर को रिमूव कर सकता है अंडर बैंकिंग रेगुलेशन एक्ट, और वो डायरेक्टर या चेयरमैन सेंट्रल गवर्नमेंट को अपील कर सकता है विद इन 30 डेज फ्रॉम डेट ऑफ कम्युनिकेशन ऑफ सच ऑर्डर. लेट अस नाउ गो टू नेक्स्ट क्वेश्चन. Regional rural banks have been created under RRB Act 1976 and their capital held is to the extent of this much percent by sponsor bank, this much percent by central government, and this much percent by state government. Let us first see the options. Option A 35, 50 and 15. Option B 33, 34, 33. Option C 50, 35 and 15%. And option D 40, 40, 20. फ्रेंड्स, आरआरबी एक्ट के अनुसार आरआरबी का जो कैपिटल है 3 लोगों के पास है, स्टेट गवर्नमेंट, सेंट्रल गवर्नमेंट एंड स्पॉन्सर बैंक। सेंट्रल गवर्नमेंट का शेयर इसमें मेजर है, सो सेंट्रल गवर्नमेंट के पास है 30%, 50%। स्टेट गवर्नमेंट का शेयर सबसे कम है, उसके पास है 15%। स्पॉन्सर बैंक के पास बाकी का पोर्शन है, दैट इज 35%। अब इस लाइट में हम इन ऑप्शंस को देख सकते हैं। स्पॉन्सर बैंक 35% करेक्ट, सेंट्रल गवर्नमेंट 50% करेक्ट, स्टेट गवर्नमेंट 15% करेक्ट। इट मीन ऑप्शन ए is the correct answer. Let us see next question. Appeal against award of which of the following is not permitted? So let us see the options. Option A Debt Recovery Tribunal, Option B Consumer Court, Option C Lok Adalat, Option D High Court. Now let us see the question once again. Appeal against award. Award means order. Of which of the following is not permitted? In case of debt recovery tribunals, appeal is allowed and appeal is to be made to Debt Recovery Appellate Tribunal. In case of consumer court, appeal is allowed in a next higher court. In case of decision of a high court, appeal can be made to Supreme Court. As regards लोक अदालत में क्योंकि ये ऑर्डर, ये डिक्री एक कंसेंट डिक्री होती है, सहमति से बनी हुई डिक्री होती है, इसीलिए इसमें अपील का प्रोविजन नहीं है। सो सी इज द करेक्ट आंसर। लेट अस नाउ गो टू नेक्स्ट क्वेश्चन। A buyer of goods get additional period for payment of documents in a letter of credit called. Buyer of goods जो है उसको एडिशनल पीरियड मिल जाता है डॉक्यूमेंट का पेमेंट करने के लिए। इनमें से उस लेटर ऑफ क्रेडिट को कौन सा लेटर ऑफ क्रेडिट कहा जाएगा? लेट अस सी द ऑप्शंस। ऑप्शन 1 डिमांड लेटर ऑफ क्रेडिट, इर्रेवोकेबल लेटर ऑफ क्रेडिट, रेड क्लॉज लेटर ऑफ क्रेडिट and usance letter of credit. Let us discuss the options. Option 1 demand letter of credit. Demand letter of credit में डॉक्यूमेंट का पेमेंट तुरंत करना होता है, hence this cannot be the answer. Irrevocable letter of credit. Irrevocable letter of credit mean वह letter of credit जिसको कैंसिल नहीं किया जा सकता, so this means this also is not our answer. Red clause LC means एलसी जिसमें सेलर को प्री शिपमेंट लोन अवेलेबल हो जाता है बिफोर एक्चुअल डिस्पैच, सो दिस इज ऑल्सो नॉट करेक्ट. यूजांस एलसी मीन्स दैट एलसी जिसमें बायर को डॉक्यूमेंट का पेमेंट करने से पहले कुछ एडिशनल टाइम मिल जाता है. दिस मीन ऑप्शन डी इज द करेक्ट आंसर. लेट अस सी नेक्स्ट क्वेश्चन. In a partnership firm, a partner makes certain payments or incurs certain liability. He can recover it from the firm if it is done in ordinary course of business. B. If it is done in emergency to protect the firm from loss. C. If it is done for the firm within or outside implied authority. Which one is correct? So question को पहले पढ़ लिया जाए. इन ए पार्टनरशिप फॉर्म, पार्टनर अगर कोई पेमेंट्स करता है या कोई लायबिलिटी इनकर करता है, देन फर्म उसके लिए लायबल है. ही कैन रिकवर इट फ्रॉम द फर्म एंड दीज आर 3 सिचुएशंस. लेट अस फर्स्ट सी द ऑप्शन. दिस इज ऑप्शन 1, ऑप्शन 2 एंड दिस इज ऑप्शन 3. सो ए एंड बी. ए, If it is done in ordinary course of business, फर्म के जितने भी पार्टनर हैं वो फर्म के बिहाफ के ऊपर काम करते हैं एंड दे हैव टू वर्क विद इन ऑर्डिनरी कोर्स ऑफ बिजनेस. सो ऑप्शन ए इज कवर्ड. if it is done in emergency to protect the firm from loss. So अगर फर्म को लॉस से प्रोटेक्ट करना है ड्यूरिंग इमरजेंसी, कोई भी एक्शन अगर कोई एक सिंगल पार्टनर करता है, सो दैट ऑल्सो इज कवर्ड. If it is done for the firm within or without implied authority, no, this is not correct. This action should be within implied authority. So it should not be outside that implied authority. Implied authority means authority a partner is having as agent on behalf of other firms. So in this case, A and B are correct. A and B only. So option A is the correct answer. Let us now go to next question. A bank can invest in shares of a company as pledgee, mortgagee or absolute owner maximum to the extent of. So this is pledgee, not pledge. These are the options. First, let us understand the law. According to section 19 Banking Regulation Act, maximum investment of bank in shares of a company can be 30% of paid up capital plus reserves of the bank, or 30% of paid up capital of the company, whichever is lower. So इन options को हमें इस रूल के अंतर्गत देखना है. 30% of paid up capital of the bank, no, इसके साथ reserves भी होना चाहिए. So this option is gone. 30% of paid up capital of the bank, और so इसमें भी हमारे पास reserves नहीं है. So this also goes. Then C, 30% of paid up capital and reserves of the bank, ये तो आता है. और 30% of paid up capital of the company, ये भी आता है. Whichever is lower, यहाँ पे whichever higher है, यहाँ पे whichever lower है. And rule is whichever is lower. Hence our answer is C. So maximum investment of a bank in shares of a company can be 30% of paid up capital plus reserves of the bank and 30% of paid up capital of the company, whichever is lower. Last question. Which of the following document is called charter of the company? इनमें से किस डॉक्यूमेंट को कंपनी का चार्टर कहा जाता है? Let us see the documents. Let us see the options. Option A, Certificate of Commencement of Business. No, it is not. Certificate of Incorporation. No, it is also issued by ROC, Registrar of Company. It is also not. Articles of Association. It is indoor document, indoor management document. So this also not is the answer. Memorandum of Association. Yes, it is outdoor management document and it is also known as charter of the company. So our answer here is for option D. Well friends, I am sure the contents of this video will benefit you. If you like the video, please subscribe our channel and thank you for watching this video.